Here's that.
I'll get it back to you.
If I could have all counsel unmute and Mr. Benzinger, are you appearing on this Dan Woods versus Dobson and Stomber case? No? Which one are you here for? You're muted.
Do you show, is it Shepherd v. K&K?
I do not have that on my docket, no.
She might have thrown me to the wrong Zoom.
You said Schnepper versus King?
Shepherd?
I think I may have one here later. So she might have sent me the wrong Zoom link. I'll go look.
Okay, sounds good. Thank you. All right, we do have Mr. Zuroff and Mr. O'Mara, so we'll go on the record. This is Dan Woods versus Dobson. This is file number 2013517. And Mr. O'Mara, you're appearing on behalf of the original plaintiff, Dan Woods?
That's correct, Your Honor.
Okay. All right, we're on the record today for a couple motions. One, I think they're both yours, Mr. Zuroff, is that correct?
Yes, there's two motions that I filed. One that I believe we were able to, or we called the court to cancel. The one related to this third-party subpoena, we actually subpoenaed or directed it to the wrong Craig Roy. So we reserved that and let the wrong Craig Roy know that he doesn't have to provide any documents. So that is not, that's not here to discuss today, but we also had our pending motion to compel to plaintiff regarding certain categories of documents. They have, in response, provided if they represent that that's what they have that's responsive to the categories except for the deleted Facebook page, then I have no reason to dispute that they've complied now with this outstanding discovery. I guess the only issue that we have, which I've already discussed with Sean, is the formatting of the documents. Some of the emails were just screenshots, so you couldn't read the attachments. You couldn't even access the attachments, and so if they represent that they provided everything responsive to our categories except for the Facebook page, and that they're going to fix the formatting issues, we don't have anything pending, but their response essentially was a motion to compel and not properly noticed, seeking discovery on their own. So I don't know how you want to handle that, because I got notice of their response on the 2nd by email, and I noticed up for today, I believe. So I didn't confer with him about it. He didn't give me a call. I don't think he conferred with his co-counsel either. He wanted to do the case. He just was added at the end of last year. And if you would have checked with Kyle, the stuff he's actually requested, Kyle and I have discussed. In fact, we went back and forth and voluntarily supplemented our discovery, both written and what was produced. And we even went one step further, as this court knows, and had a motion to compel hearing where you decided some of the outstanding discovery issues, and including regarding any documentation given to a hunter that comes onto my client's hunting property and what he leaves with, and that anything responsive to that has already been produced. And that was all done in preparation to take each individual party's deposition. So we resolved all those issues, took the deposition, and now apparently they want another chance to do that without anything really changing in the case. The Bay County case they point to, they've known about from the start. They brought it up several times to me in the documents that were related to that. I don't see the relevance. It's not related to the same herd. It's not related to the same even type of animals. And it's not related to, in fact, the subject elk here are different than the ones that are at issue in the Bay County case because they're kept at separate locations and separate farms. So I failed to see the relevance. They also knew about this other case. Kyle knew about it before taking my client's step. There's a new piece of litigation they point to that we haven't even been served with about another dispute unrelated to this one. I don't see what the relevance is there either, but I mean, I rarely ever ask for fees, but this is one instance where I would ask whether or not fees are appropriate, considering we've never discussed any issues with me. These have all been something that his co-counsel and I have talked about. We've dealt with the court. We've had numerous meetings with you about whether or not discovery was the issues we were getting through and getting to the point we could take the depositions. And now the only thing that's really changed is new co-counsel being added, and suddenly he wants a chance to redepose my client. I mean, without anything changing in the case other than him being added. And without any new evidence coming to light that would justify any kind of deposition, and certainly not a full-blown redeposition of my client. So that's my piece, and I'll leave it to Sean to take it from there.
Well, I want to clarify something first of all before because
Sure.
I'm a little bit lost here. Can we go back to your motion, Mr. Zuroff, that's up for today? And let's address that first, because you're indicating that may not be an issue anymore, right?
As long as they are, if Sean confirms that they're going to fix the formatting issues and that they provided all responsive documents, I would have actually taken this one off the calendar too if I didn't read the response before getting a chance to call the court and adjourn this hearing. I mean, as far as the Facebook page, the deletion of the Facebook page, I plan to bring a separate motion related to that on spoliation. But that isn't in front of the court today. That's something that was outstanding discovery that got deleted instead of produced. And we'll address that separately. But as far as our motion goes, we had largely taken care of everything except for the formatting issues on the document coming into today.
Okay, Mr. O'Mara, can you speak to just that issue, and then we'll get to everything else here in a minute?
So I did produce the documentation requested. I can produce the Facebook. It's been deleted. There's no ability for me to do so. So I think that would be, in terms of his motion, I don't think there's any pending issue beyond, he didn't like how it was sent over formatted wise, and I'll try to get it formatted better for him.
We just can't even read the attachments. I mean, if you look at everything that's attached to his response, all the emails have reference attachments. When you look at the attachments, and they're so small you can't read them. And then, I don't know. All they have to do is print up the email with the attachment and produce it, as opposed to screenshot it, and they'd have a proper format to produce the documents.
Okay, Mr. O'Mara, can you do that?
I think that'd be easy enough to accomplish. It was kind of it was sent over kind of late, and I sent over what I got. So, the timeline on this with the holidays was kind of rushed, but yeah, I'm happy to provide formatting, printing out the emails, and then I can mail them to.
Okay, when could you do that by?
I wouldn't take more than I am leaving for Chicago this week. I'll try to get it this week, early next week at the latest.
Okay, within 14 days?
Oh yeah, that'll be fine.
Okay, so Mr. Zuroff, if you could just prepare an order reflecting that plaintiff has agreed to turn over that document in a better format within 14 days.
Yeah, I can do that.
Okay, great. Now, the other issue, Mr. Zerhoff, did you say, or maybe Mr. O'Meara, has there been an additional motion, Mr. O'Meara
Well,
filed?
in my
No, okay.
response, I guess what I'm trying to highlight is that defendant has not produced anything in terms of discovery either. And there's been documentation provided in a separate lawsuit. It should have been turned over to us in this lawsuit. And I have spoken to Kyle and co-counsel on this, and this has been an outstanding issue. So in terms of the herd and this TB testing that we were trying to obtain from defendant, the herd goes to a herd number where the location of the herd, where they're located. It doesn't go to animal type. So defendants take the position that there's two types of animals and that there's two types of herds, but that's not true. There's one herd, and it was at an individual, a Dale Reinhardt's premise, and that's where his client obtained the elk that were ultimately sold to my client. That herd, the TB testing ended up being faulty, and he sued the vet for that. So that it goes to their counterclaim, their breach of contract, right? And it's an issue that we need to delve into, and why we're getting some of this documentation from pleadings from a different lawsuit is kind of, for me, it doesn't make any sense. That should have been provided. They've known that the TB testing of the elk that are a part of this lawsuit was faulty, and they've known that since April of 2020. Why didn't they turn that over? That hasn't been produced in this lawsuit. So, and I do want to talk to, or I would like to ask questions of Mr. Dobson about that. I can motion separately. I was more highlighting the issues in terms of discovery for us still that outstand. And so that was the primary purpose. I would agree that in terms of asking for a dep, I don't think, I've talked to Lance, he doesn't want to redepose anybody. I could file a separate motion. That'd probably be the proper vehicle for that.
So as far as the testing goes and the relation to this case, as I said previously, they were kept at separate locations. So the elk that the subject of this case were kept at a separate location. Dale Reinhardt, K&W Whitetails, has two separate locations. These are separately kept, and they were separately tested. The issue with the whitetail deer that were subject to a clerical error related to the testing is totally separate, has nothing to do with this case. And Kyle, his co-counsel, and the attorney before that all knew about all of these allegations. They knew about it from the start. They've talked to me about it. They've raised it. I've heard about it. I know Sean's new to the case, so he raised it again. But this has all been discussed. This was all something that has been addressed between counsel leading up to us taking the deps and going through the hoops to take care of any outstanding discovery issues before both parties got to post. We even had a hearing before you, Judge, related to the sales documentation, which he asked for, which we went through all that. And, at the end of it, it was found that we produced the responsive documents that we have. So I don't want to go back through and redo the extensive work we've done in discovery here. I think we're at the tail end of it, and I don't want to redo this stuff. I don't think it's fair to either side.
Well, I agree to a certain point. I do. I think the facts of this case are there's a lot that's pretty simple. That, elk we could show that elk were taken and that those elk were taken. That's admitted. There's no such thing as self-help repossession, even if there's a theory of, these weren't paid off. There's no such thing. So I feel confident in terms of, moving forward with our motion. It's just that there's been apparently some games with discovery throughout, from what I can tell.
Actually, there hasn't.
So, okay.
I mean, if you talked to his co-counsel, you'd know there hasn't been. And we've been going back and forth. We have talked about every issue that's been outstanding.
Okay,
I know we've had numerous conferences with the court where it was reported where the discovery is we're working through the issues. We've had a good working relationship. I think the judge can attest to this. Kyle wasn't raising any, oh, there's outstanding issues here. In fact, we had a hearing on it. We handle all this handled before, like you would, before you take the primary person's dep on the other side of a case.
I don't understand why there's documentation to turn over documents that isn't submitted or turned over. It's not part of the file, and the file doesn't.
Okay, all right, I think these are discussions you guys can have between the two of you off the record. It really doesn't have anything to do with the court. Mr. O'Mara, I think you're right from a procedural standpoint, to the extent that there are matters regarding discovery that your side believes would be the subject of a motion. I mean, I think you would need to file a motion, identify those, and we'd have to proceed that way. I think, all counsel might benefit from some further off the record discussions here as to, if only to narrow the grounds for a potential motion by Mr. O'Mara's side. So for that reason, I think it would be, I hate to just stand on form and, just make you file a motion for the sake of filing a motion. But I think some further discussions might at least narrow the issue a little bit so that we can really focus in if there are things that need to be compelled, focus in on those things. So the court's going to decline to take up that issue today. And to the extent following further discussions that there are matters, Mr. O'Mara, then the court will just look for a motion from your side and we'll take that up in due course. Otherwise, Mr. Zuroff, I'll just ask that you prepare an order, as I stated previously. And I think that's all we have.
If I state it as we'll print up the document so that they show the full attachments to the emails, is that? I would like to have that sufficient detail just so that I make sure that it comes back in the proper form.
Yeah, I think that's reasonable. Yep.
Okay. Thank you, Judge.
All right.
Quick question. There was a stipulated order that was sent in regarding pushing out 3 days. Did the court receive that?
You're kind of breaking up there, Mr. O'Mara. I'm not getting everything that you're saying.
He was referencing the stipulation to extend out the dispositive motion deadline. Is that right, Sean?
Correct.
You know what, I don't know if I've seen that yet, or is that something that you guys have filed recently?
Yes.
Okay, I just may not have had a chance to sign it yet, but I'm not gonna object to it. I'll certainly sign that once I get it.
Thank you, Your Honor.
Okay,
Thank you.
all right, thank you. You're both free to disconnect at this time.
Appreciate it.
Judge's copy.
Oh, yes. Oops, sorry.
Thank you. Okay, Ms. Alsaba.
Yes, good afternoon, Your Honor.
Okay, good afternoon. We're on the record in case number 2414408, Ally Bank versus Pinnacle Insulation and Stomber. This is set for a status conference today, and it was set for 2 o'clock. It's now a little bit after 2. I do not see Mr. Stomber appearing in the Zoom waiting room. So Ms. Alsaba, can you kind of give me an update as to where we're at with this?
Yes, Judge, thank you. I have not had contact with Mr. Scramble. He hasn't reached out saying he wasn't, and we haven't been able to come to a resolution yet. I have prepared a motion for summary disposition that I'm going to file probably today. So that is where we're at.
Okay, so I guess what I'm going to do then, just for purposes of status conference in this case, is just note that plaintiff is filing a motion for summary disposition. That'll be noticed for hearing. I'll probably set this for a control date at like 60 to 90 days out, just so there's a next date on the calendar since you haven't got that motion filed yet. And in case for some reason that doesn't happen.
I'm sorry about that. We did reach out to your office and we received a date for March 4th for the motion.
Oh, okay, great. Sounds good. All right, then I'll set it for a status conference on March 4th along with that motion. And we'll go from there. Anything else I can address for your side here on the record today?
Since we're here, Your Honor, I'd like to request that we move to set aside Defendant Pinnacle's answer and affirmative defenses, as they're a limited liability company and they haven't filed the answer with representation or an appearance from representation legal counsel. So I'd like to move to set that aside.
And I think that's probably appropriate. Maybe can you just make that as part of your motion for summary disposition? And
I have. Yes, I will do so.
Oh, okay, great. Yep. All right. So I think that's probably appropriate, but I'll address that at the hearing on your motion in case Mr. Stomber appears or someone on his behalf has some type of argument in response.
Okay, great. Thank you, Your Honor.
Okay. Anything else I can address for you today?
Nothing else, Your Honor.
All right. Thank you. You're free to disconnect at this time.
Have a good day.
Thank you.
Hello.
Hello.
All right. Good afternoon. Like Mr. Corcoran is signing in here.
Good
Okay,
afternoon.
we got Mr. Corcoran. All right, good afternoon. So we'll go on the record. This is West versus Spink, case number 2314111 NZ. We have both counsel connected. And then I'm just gonna touch base with counsel, but we also have a separate, but I guess somewhat related case set for hearing later today at 3:30. involving the same parties. That's file number 2314281. But I'm just going to put this out to council since the first case is set for status conference today. On behalf of plaintiff, Mr. Corcoran, can you just kind of tell me where things are at generally and what your thoughts are on how to proceed today?
Judge, I had originally set this matter and the other matter later today for hearing. And I contacted your staff and I contacted Mr. Gilbert earlier this week. And we've renoticed both of those hearings for February 21st at 9:30. I sent an email over to your assistant this morning with the notice of hearings. I have a explorative surgery Friday. I have to meet with my doc today at 4:30 in Traverse City. So I wasn't able to do those hearings, and that's why we had to reschedule them. I couldn't miss this. It's kind of important that I have this thing on Friday. So.
All right, Mr. Gilbert.
No objections.
Okay.
I mean, we haven't made progress on either case, but I don't have any objection to medical issues.
This would be, we intend to have the hearing on the 21st, Your Honor, and this would be my last requested adjournment.
All right, okay, then that's how we'll proceed. You both kind of addressed this, but both these cases have been kind of languishing, and I don't want to just keep putting these off, which we, have been doing. So we'll need to move forward on the 21st. The court is unlikely to grant any further adjournments.
Okay.
And so we'll move forward as currently scheduled. And all parties are free to disconnect at this time.
Thank you, Your Honor. Have a good day.
All right, Mr. Fragel, are you able to hear me okay?
Yes, I am, Your Honor.
All right, and I see we have Mr. Charnes connected, so we'll go on the record. This is Secretary Kyle Charnes versus Secretary of State, case number 2414612. The record should reflect that Mr. Fragel and his client are present by Zoom. Mr. Ziegler, on behalf of the people, is present here and the Secretary of State is present here in the courtroom. This is Mr. Charnes' petition for hardship restoration of his driver's license following a first implied consent suspension. Mr. Fragel, I did have a chance to review the petition that you filed and the basis. Did you want to take some testimony from your client today?
Certainly, Your Honor.
Okay. Mr. Charnes, if you'd raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand, and Mr. Fragel, whenever you're ready, please proceed.
Mr. Carnes, you were operating a vehicle on August 18th, 2024, and ended up getting arrested for operating while intoxicated or high BAC. Is that correct?
That's correct.
And you later pled guilty to operating while intoxicated, correct?
Correct.
Your driver's license was suspended due to refusing to take the chemical test that was requested by the law enforcement officer. Is that correct?
Correct.
And you have since been complying with that suspension, correct?
Correct.
Is that your first implied consent suspension?
Yes, it is.
Now, has that suspension imposed a hardship on your lifestyle?
Yes, sir.
An extraordinary hardship?
Yes.
How far do you live from work?
45 minutes.
And are you an educator at the school system?
Yes, I am.
And what time do you need to be to work?
7:30 at the latest.
And how late do you stay on an ordinary day?
On a normal day, 4:30. On a good day.
Are there days you must stay later than that?
Yeah, there's several depending on school events, athletic events, board meetings, things of that nature.
So what's the latest you have to stay at the school?
Games get over between, right now we're in basketball season, so 9:30, 10 o'clock could be the latest.
Now, how have you been, is there any public transportation available at that hour, either evening or morning?
Not that I'm aware of, no.
All right. Now, how have you been getting to work? Are you relying on family members or coworkers?
I've been relying on, my brother, my wife, and then sometimes coworkers.
Okay. Now, have you completed any alcohol education or alcohol treatment since your arrest?
Yes, I've completed the alcohol highway safety training, victim impact panel, and I'm currently in the prevention relapse program, as well as several AA clubs.
How often do you go to AA?
Once or twice a week. Those are via Zoom. No, obviously can't drive there.
And how long is the relapse prevention scheduled for? How many months?
I believe I have 4 months left, 4 more classes.
Is that 4 out of 12?
Yeah, I have 8 total, 4 of 8
Okay.
left. Yeah.
Now, did you have any bond violations when you were on bond?
No, I did not.
When was the last time that you consumed alcohol?
August 18th.
The day of your
24. Yes.
Yeah. And what is your attitude toward alcohol when all the probation is finished and your relapse prevention is finished? What is your intention with alcohol?
Yeah, I've had obviously my issues in the past, and you know, I've accepted I'm just someone who can't drink. And that's been a good realization for me, and so that's what I plan to continue, is just to avoid it, cause nothing but problems for me. So that part of my life's over.
All right. Yeah, I have no further questions. Thank you.
All right, thank you. Mr. Ziegler, did the people take any position based on Mr. Carnes' testimony as to whether the court should grant the restricted license?
Your Honor, I think Mr. Carnes is technically eligible. He meets the statutory requirements. I don't take a particular position on what the court does in terms of a hardship. I leave that to the court's discretion.
Was that charge in this county?
It was, Your Honor.
Did you prosecute? Do you have any information regarding the underlying facts or any aggravating circumstances that you're aware of regarding?
Not that I'm particularly aware of, Your Honor. It was a high BAC. I don't remember the specific blood alcohol content that was put down to an operating while intoxicated. I think it's correct. To the best of my knowledge, he had no bond violations of any kind.
Okay. All right. Mr. Carnes, based on your work as an educator, based on the treatment that you've undergone since this incident, are you currently still on probation?
Yes, Your Honor.
Okay. Based on the fact that you're currently being supervised, and I'm assuming that drug and alcohol testing is part of your probation, is that correct?
That is correct.
Yeah, okay. So there is some oversight and supervision to make sure that you're not drinking, and to the extent that you are, I'm sure that would result in a violation of your probation and additional penalties. So given all of those factors, the court is satisfied that you do qualify for a hardship exemption. The court is satisfied that concerns regarding public safety are mitigated by the fact that you continue to be supervised on probation. So the court will grant you a restricted license that will allow you to drive only to and from your residence and your place of employment, and in the course of your employment, to and from substance abuse treatment or any other support group meetings such as AA, any transportation to and from any treatment for a serious medical condition, and to and from your probation office to the extent that you have to report for probation. If you are driving pursuant to this restricted license, you need to have with you proof of your destination, and that the fact that you're driving at that time is appropriate given where you're driving to. In other words, if you're driving to an AA meeting, you need to have proof that there's an AA meeting occurring within a reasonable amount of time while you're driving. Again, if you're driving to or from work, that it's at a time that you would reasonably be expected to be driving to or from work. And the responsibility is on you to provide proof if you are stopped for any reason that you are driving in accordance with your restricted license. Mr. Fragel, you did provide a proposed order, so the court will sign that order. And if you need copies of that, you can contact the clerk's office, okay?
Yes, thank you, Your Honor. That
right, Mr.
order you
Fragel,
have, Your Honor, just to be clear, does that have the driver's license number underneath the petitioner's name?
It does, yes.
Okay, thank you. Just to make sure.
Okay, thank you. That concludes this hearing for today, and you're both free to disconnect.
Thank you.
Thank you.
Thank you. We'll see you, Judge.
Okay, thank you.
Oh, I said, do you want one of these giant?
All right, looks like we have all council connected. So hold on one second and we'll go on the record here. Okay, we're on the record in Antaya versus multiple defendants related to Kalkaska Hospital as well as Munson. This is file number 2213998. And if I could have counsel put your appearances on, starting with the plaintiff, please.
Good afternoon, Judge. I'm Emily Peacock for the plaintiff.
Good afternoon, Your Honor. Richard Heinrich. I represent PA Wells, Dr. Hunter, as well as Sound Physicians.
Good afternoon, Your Honor. Nick Artave on behalf of Munson Healthcare and Munson Medical Center.
Good afternoon, Your Honor. Jonathan Martin on behalf of Dr. Saminsky and Northwestern Michigan Emergency Physicians, PC.
Good afternoon, Your Honor. Sandra Lake on behalf of Mr. Shellup, Dr. Craven, and Kalkaska Memorial.
All right, thank you. We're on the record here today. We've had a number of motions for summary disposition as to causation filed by three, I'm going to kind of term it as three groups of defendants here in this case. And this is the date and time set for oral argument. Before we get started though, I mean, I've got a bit of a problem, and I'm not you know, stating that any of the parties have filed late briefs, but as a matter of fact, and due to the holiday and court closures, while I did receive the three motions by the defendants who filed the motions back in November and December, and I have had an opportunity to read and go through the motions. I did just receive yesterday the plaintiff's response, the two responses that were filed that are contained within these two binders, and then also some replies from some of the defendants that I received yesterday as judges' copies. And again, I'm not in any way suggesting that any of those were filed untimely, but in terms of judges' copies and when they got to me was yesterday afternoon. So the gist of it is I've not had a chance to review the responses of the plaintiffs. I had a full docket yesterday in Otsego County and a full docket here in Kalkaska. So while I've read the defendant's motions, I haven't read any of the plaintiff's responses or any of the replies that were filed by any of the defendants. So essentially that puts me in a position here where, I mean, we could go forward with oral arguments today. The problem for me in that is that part of the purpose of oral argument is for me to be able to ask questions, and particularly given that these motions are pursuant to C10, which is heavily factually related, it doesn't give me an opportunity to really meaningfully engage counsel should I have questions that I need to help me rule on these motions. So it would be my suggestion in light of that we adjourn the oral arguments set for today, renotice them for next month when I've got an opportunity to go through. And again, I would note that while I expect that plaintiff's responses are somewhat similar, given that the arguments are somewhat similar, and I suspect that what's contained within the two binders is probably largely, duplicative. There is substantial information I think that I would need to go through. And again, given that this is factually dependent, I want to have an opportunity to really go through any exhibits that the plaintiffs filed. So that would be my suggestion. But I want to give counsel an opportunity if anybody has an objection or thinks that wouldn't be appropriate. Ms. Peacock, on the plaintiff's side of things, what's your view?
Judge, I don't have any objection. Plus the audio seems a little wonky today. I don't know if you can hear everybody.
You were breaking up a little bit, but I haven't had problems throughout the day today, generally. Mr. Sir Heinrich?
I think in light of what Your Honor is telling us, it makes sense to adjourn it. I'd prefer that our oral argument take place after you've had a chance to go through all the briefing. I think it'll streamline things for everybody too, if you're able to do so.
All right, thank you, Mr. Martin.
I have no objection to adjourning the argument in light of what the court has indicated.
All right, Mr. Arteev?
No objection, Your Honor. That's fine. Like Mr. Sir Heinrich said, we'd rather you have everything you need to make a proper ruling on this.
All right, and Ms. Lake?
No objection.
Okay. All right. Then the court is going to set this for hearing on its motion day on the, do you have that date?
It is gonna be. Looks like it'll be the 4th.
Okay. I can't give you a time yet, but the court will set this for hearing on February 4th, which is my motion day here in Kalkaska. And I'm going to try and set aside a full hour, given the number of attorneys and the nature of the motions here. I think that'll be enough time. So the court will send out notice of the date and time of that hearing in February. Ms. Peacock, anything further for the record that you'd like to state today?
We were scheduled for a status conference, Judge.
Yep, I would anticipate that following the argument and my ruling on the motion in February, that will move right into a status conference at that time.
Oh, no problem. That sounds good. Thank you.
Okay. Any defense counsel with anything further that you would like to add to the record today?
Yes, Your Honor. Jonathan Martin, I would request the opportunity to file a reply brief since we, given the holidays and when we received the various responses, we did not think there was sufficient time to get one out before today's hearing.
I don't have an objection to that, and just make sure that when you file it with Kalkaska County, again, my office is actually in Otsego County, so any judge's copies should be sent to the Otsego County address, even though the actual filing needs to go to Kalkaska County. And sometimes that's part of the problem, like with plaintiff's responses. I'm sure, I'm sure you mailed them a while ago, but I didn't get them until yesterday. So sometimes it takes a little bit of time, given the nature of the 3-county circuit. Okay, thank you. That's all I have for today then, and all counsel are free to disconnect at this time.
Thank you,
Your
Judge.
Honor.
Thank you.
Thank you, Your Honor.